How are laws made in Kenya? The full process explained simply. What is a law and why it needs a process? A law is an official rule that guides how people live, behave, and interact in society. It tells us what is allowed and what is not, and it helps protect people's rights and maintain order. Because laws affect everyone, they must be made carefully, not by one person's decision, but through a fair and public process that includes the voices of representatives chosen by the people. In Kenya, this process happens through Parliament, which is given that power by the Constitution of Kenya, 2010. Which are the main institutions that make laws in Kenya? There are three main arms of government in Kenya: the legislature makes laws, Parliament. The executive implements laws, President, Cabinet, Ministries. The judiciary interprets laws, courts. Our focus here is the legislature, which is Parliament. Parliament has two parts: the National Assembly represents the people of Kenya, the Senate represents the 47 counties. Both houses play a part in lawmaking, especially for laws that affect counties. Steps of making a law. Step 1: the idea for a law. Every law begins as an idea, a recognition that something in society needs to change or be controlled. The idea can come from a member of Parliament, MP, the government, through a cabinet secretary, a senator, a committee of Parliament, the public, through petitions or proposals. Once the idea is clear, it's written down as a draft law called a bill. A bill is not yet a law, it's a proposal for a law. Step 2: drafting the bill. Drafting is when the idea is turned into proper legal language by professionals. Usually, it's done by the Parliamentary Council in the Attorney General's office, or the legal department of Parliament. The drafters make sure the bill is written clearly and logically, does not conflict with the Constitution, can actually be enforced in real life. When the draft is ready, it is printed and given a title, such as the Education Amendment Bill 2025. Step 3: publication in the Kenya Gazette. Before a bill is discussed, it must be published in the Kenya Gazette, the government's official record. The publication allows the public and MPs to read it and prepare for debate. By law, a bill must be published at least 14 days before it is formally introduced in Parliament. This makes the process transparent and democratic. Step 4: first reading. The bill is formally introduced in Parliament. This is called the first reading. At this stage, the title of the bill is read out loud. There is no debate yet. MPs are only informed that the bill exists. The bill is then sent to the relevant parliamentary committee for further study. Step 5: committee review and public participation. The bill goes to a departmental committee that handles that area. For example, a health-related bill goes to the Health Committee. This committee reviews the bill carefully, consults experts, stakeholders, and members of the public, holds public participation sessions, required by the Constitution. Suggests changes, called amendments. Public participation ensures that ordinary Kenyans have a voice in the lawmaking process, a key democratic principle under Article 118 of the Constitution. Step 6: a second reading. After the committee finishes its report, the bill goes back to the main chamber for the second reading. Here, MPs debate the general principles of the bill. Is this law necessary? Is it fair and beneficial to the people? Could it cause problems? At the end of this debate, MPs vote. If the majority support the bill, it moves to the next stage. If not, the bill fails and stops there. Step 7: Committee of the Whole House, detailed examination. If the bill passes the second reading, Parliament forms a Committee of the Whole House. This means all MPs act as one large committee to go through the bill clause by clause. In this stage, MPs discuss every line and detail. They can propose specific amendments. Each proposed change is debated and voted on separately. This stage is where the technical details are polished and corrected. Step 8: report stage. After the detailed review, the committee prepares a report showing all the changes made to the bill. The Speaker of Parliament then calls for a session where the report is presented. MPs debate the final version of the bill, focusing on whether it now reflects what Parliament and the people want. Step 9: third reading. This is the final debate and vote in that house. At this point, the bill is debated one last time. Only minor corrections can be made. MPs vote to pass or reject the final version. If the majority vote yes, the bill is passed by that house. Step 10. The Senate's role. If the bill affects counties, it must be sent to the Senate. The Senate goes through exactly the same steps. 1. First reading. 2. Committee review and public participation. 3. Second reading. 4. Committee of the whole. 5. Report stage. 6. Third reading. If the Senate approves the bill without changes, it moves to the President. If the Senate changes something, it is sent back to the National Assembly to agree or disagree. If both houses disagree, a mediation committee is formed, made of equal members from each house, to create a compromise version. Step 11. Presidential assent, approval. Once both houses agree, the final version of the bill is sent to the President. The President has 14 days to write heavy checkmark, sign the bill, give assent. If he does, it becomes law. Crossmark rejects the bill, withhold assent. If he does, it goes back to Parliament with the reasons. If the bill is returned, Parliament may change it as the President suggests, or reject the President's concerns by a 2/3 majority vote. If Parliament overrides the President's rejection, the bill automatically becomes law. Step 12. Publication as an Act of Parliament. Once signed, the bill becomes an Act of Parliament. It is published in the Kenya Gazette as a formal law. The publication gives it legal effect and tells everyone in the country that the new law exists and must be obeyed. Step 13. Implementation and enforcement. After a law is passed, the executive branch, government ministries, agencies, and county governments, is responsible for enforcing it. The judiciary interprets it when disputes arise. The public must obey it. Sometimes, laws need regulations, smaller rules, made by cabinet secretaries or county assemblies to explain how they'll be applied in detail. Step 14. County legislation. Each of Kenya's 47 county assemblies also makes county laws, but only for matters that belong to counties, such as agriculture, health services, county transport, markets, and local trade. The process is similar to the national one: idea draft, public participation, debate, vote, governor's assent, publication in County Gazette. Once signed by the governor, it becomes a county law. County Act. Step 15. Constitutional safeguards. The Constitution of Kenya, 2010, protects the lawmaking process by requiring public participation at all stages, separation of powers, no single body controls everything, checks and balances, Parliament makes, judiciary interprets, executive enforces, transparency and accountability, debates and voting are recorded publicly. These safeguards prevent misuse of power and protect the rights of citizens. How a law moves from idea to law. Let's use a real-life example to make it clear. Problem: many Kenyans suffer from online bullying and hate speech. Step 1. An MP proposes a cyberbullying bill. Step 2. It's drafted and published in the Gazette. Step 3. First reading, a title read in Parliament. Step 4. Committee reviews it and invites public views, teachers, parents, youth groups. Step 5. MPs debate the bill and vote yes. Step 6. Committee of the whole examines each section, adds penalties, and defines terms. Step 7. A bill passes third reading, sent to the Senate. Step 8. A Senate approves it, sent to the President. Step 9. President signs, becomes Cyberbullying Act. Step 10. It's published in the Gazette and now can be enforced by the police and courts. Why is the process long? Making a law in Kenya takes time on purpose. It's designed to allow public input, prevent bad or rushed laws, ensure fairness and quality, reflect the will of the people through their representatives. A rushed law could harm citizens, waste resources, or violate rights, so Kenya's process values care and debate over speed. Lawmaking as a reflection of democracy. The process of making laws in Kenya is one of the most important parts of democracy. It ensures that laws come from the people's voice, not from individual power. From the first idea to the final signature, every step allows debate, review, and accountability. That's how Kenya builds a system where rules protect, rights are respected, and leaders remain answerable to the people. In simple words, laws in Kenya are made by 1. Thinking of an idea. 2. Writing it as a bill. 3. Discussing and changing it in Parliament. 4. Approving it by MPs and senators. 5. Getting the president's signature. 6. Publishing it as law. 7. Enforcing it by the government. That's how an idea becomes a rule that governs everyone, fairly, openly, and democratically.